Okay, good morning, everybody, and welcome to this Get in Shape webinar. I'm Mark Benicevic from Partners Life, and it is my absolute pleasure to welcome today you to this webinar with David Greenslade and Nick Summerfield. David Greenslade, of course, as many of you know, is the founder and director of Strategi, one of the leading entities in New Zealand around compliance and education for financial advice. Nick Summerfield is a financial services lawyer from Anthony Harper. He's a partner, and so he'll be coming with a legal bent to this webinar. As usual, please fire questions as we go into the Q&A option in chat, and the Q&A option in the Zoom panel, and I will fire those questions through to our hosts as we go. So without any further ado, I'll hand over to David. Thank you both very much for coming along this morning.
Great, thanks very much, Mark, and welcome everyone. So I know this whole concept around the advice process and how you use documents and how do we sort of prove that we're compliant is stressing out many. So in our day-to-day role, we're working with some of the biggest financial institutions right down to sort of single advisor businesses. And what we find is that we need to tailor the advice documents and the processes to the type of products and solutions that particular FAP is offering, and also the way they want to deliver it. So there is no cookie cutter approach to how this works. Now, as well as sort of working on the compliance and education side at Strategi Group, I'm also a practicing financial advisor, and I've been a financial advisor for 32 years, and I still look after some clients through the company that I'm a shareholder and chairman of. So I understand the pain that financial advisors are going through as they're grappling with how to re-engineer their business to get compliant documents. So let's have a brief look at the agenda and a couple of things that we want to have a look at. So the first thing we want to do, and this is really sort of the area that Nick's here to talk through, is what is the legal framework around how this advice process and the advice documents, what's the fundamentals and the structure around what that is? And then as we go through, we'll talk about what is compliant advice. And then we'll talk through what's the actual advice process and is it fluid or is it structured and things like that. And then we'll finish off by talking around assessing compliant advice. So how do we know if our advice is compliant? Along the way, what we'll do is we'll talk through whole lots of trends, what we're seeing in the market, what we've seen overseas, what's happening here in New Zealand, some do's and some don'ts. As we sort of progress through it. But as we go, feel free to ask a heap of questions throughout. Now, a couple of things I just want to sort of say as part of an overall framework, and I'm sure sort of Nick will pick up on them as we go, and that is we've moved into the Financial Markets Conduct Act. So a lot of people are looking at that and going, wow, that's pretty scary stuff, and that there's bigger penalties and more obligations. So what we should do is put more stuff into our advice process. So sadly, what we're seeing is people are taking existing advice processes and adding more paper and adding more client sign-offs into the actual process. And that is really counter to the purpose around the regime. So believe it or not, hard-coded into the purpose statement for FMCA is two key things that often people overlook. The first one is to avoid unnecessary compliance costs. Now, sure, within a business, compliance costs will go up because there are more obligations and bigger penalties. But it doesn't mean to say we need to make the advice process more complex for our clients. And the second one is around to promote innovation and flexibility in the financial markets, because the FMC, as it's been sort of amended by FISLA, is designed for both delivery of digital advice, via robo advice, and also advice from us as humans and as FAPs. So we need to be thinking about flexibility, because this new advice regime actually encourages us to do that, and it provides the flexibility for us to do it. So where people are saying that the law is stultifying them and holding them back, it's actually the reverse. It's our mindset around how we're approaching this that is holding us back. The law is giving us heaps and heaps of wriggle room. What we need to understand by talking with lawyers and talking with compliance experts is how much wriggle room do we have in this principles-based regime, and how do we best deploy that to get good client or customer outcomes? So I'll pass across to Nick to start talking through some of these legal obligations and the underlying framework. So over to you, Nick.
Thanks, David. Yeah, look, before I kick off with the detail, I think probably endorse those comments. I mean, this is a regime that's designed with principles rather than, for the most part, black letter rules, and it's designed to be flexible. So there is heaps of scope to do things in new and different ways and kind of challenge previous ways of thinking. The flip side of that is it's scary because, as David said, it's in the FMCA regime, and there are, if you go and read it, which obviously everyone should do, there's some quite significant penalties for worst case scenario for not doing it right. So there is still a natural temptation to not overcook's the wrong way to say it, but to be conservative, which makes complete sense. But I guess I would say embrace the flexibility and the new way of thinking in a way that complies with the obligations and duties of the code, which we'll come to, but challenge what you're doing and don't feel that the law is holding you back, rather is setting up a framework within which to do things how you want to do them. So talking to the detail in here, I mean, I guess the first point to make is that the advice process itself isn't legislated for. There's nothing in the Act or in the code that says this is the process you must follow. But it does need to be carried out in a way that makes sure that legal requirements are met. So this slide here really just is a bit of a rehash and a refresher of all the core duties that those giving financial advice have. Some are more relevant and some are less relevant to the provision of financial advice and the advice process. So what we might just do is touch on some of the key points, kind of in a bit of an order of relative importance. First one, I think, is the duty to ensure a client understands the nature and scope of advice. So if you're giving financial advice to a retail client, you can't give financial advice to a retail client unless you've taken reasonable steps to ensure they understand the nature and scope of advice and any limitations. And this is different from understanding the advice itself, which is covered by code standards, which I think we'll come to on the next slide. But in practice, the simplest way to do that really is a clearly articulated scope of engagement or similar document, depending on your particular process, and making sure you've got disclosures that comply with the Act, and then testing that with clients so it's really clear to them what you're advising on and what you're not. Next, we've got the duty to exercise care, diligence, and skill. So a person giving regulated financial advice has to exercise the diligence, care, and skill a prudent person in the same occupation would exercise in those circumstances. This really means making sure your advice is robust and carefully considered. If you're in a position where you're engaging others to give advice, or if you're a FAP, or have others helping you, it's around making sure they're competent, making sure they've got good processes in place. Duty to give priority to clients' interests. Everyone will be well aware of this, I think, but effectively what it says is that if there's a conflict between your client's interests and the interests of someone else associated with the advice, that might be you or your advice business, you have to prioritise your client's interests, and you have to take all reasonable steps, which is a high threshold, to ensure advice isn't materially influenced by those other interests. It creates a hierarchy, so it basically means that you have to put your clients first. It's not a balancing act. It basically says, clients come first. Moving down from that, two similar duties. So there's a duty to meet standards of competence, knowledge, and skill, and duty to comply with the code of conduct. These basically serve to bring the code obligations, which we'll come to, into the core FSLA liability regime. Effectively, it gives the code the force of law, and the flip side of that is if you comply with the code in the course of your advice process, then you'll comply with these duties. Duties to make prescribed information available and not to mislead. Effectively, these link back to the disclosure regulations, which we've obviously all talked about before. They are a key part of the advice process, if not the advice itself, in terms of quantifying and helping your clients understand, what's going on and, where they fit into everything and coming back to nature and scope and limitations and the like. And there is liability under the Act if information in those documents is false or misleading, if it's materially adverse for clients. And then finally, a duty relating to offers that contravene the Act or the regulations. Effectively, this says that you can't recommend as part of your advice process an acquisition of a product if you know that it's a contravening product. So if you know effectively that it's unlawful because it doesn't comply with the legal requirements in some way. So that's legal obligations. We'll hand back to David. Do you want to talk to the code?
Yeah. Well, but before we move on from there, so thanks for that, Nick. There's a couple of things there. If we go down and everyone just look at that bottom bullet point about don't make false or misleading statements and omissions. So by itself, that sounds fine. But then we sort of tease this out and we go, how do we practically demonstrate that in our advice process and in our documentation? So often when we're working with clients, the FMA talk to us around balanced advice. So when they're talking about a balanced advice process, they're talking about, by all means, talk about the product that you're recommending and the key features and the benefits and why that's suitable. But then on the flip side, you need to be able to talk about the key risks and disadvantages so that the client understands the pros and also the cons of the recommendations. And so that's why you shouldn't be omitting the things that you don't want the client to know about. Because what we see is advisors, when we talk to them, we say, hey, look, you haven't put anything in here around the key risks and disadvantages. And their reply often, sadly, is, well, we don't want to scare them away. If we told them the things that aren't good about the product, they may not go ahead. And so we're going, well, you've got to have this balanced approach in all of this. And this is hard-coded into this section 431. And then when you sort of go back up and you look at things like competence, knowledge, and skill, that needs to be sort of interlinked into how all of this sort of fits in. And also, when you're looking at things, you've got to look at some of this stuff and go, right, how is the client going to understand all of the things we're talking about? Because if you use jargon, well, then jargon may make sense to you, but it may not make much sense to clients. So a bit further on, we'll talk about clear, concise, and effective. But as you'll see, as we skip through some of these slides, that all of these duties are transposed through into the way we deliver advice. So if we flick on to the next slide, where we're talking about suitability and client understanding, what we have in here is firstly, Nick's outlined initially the law, and the law refers to the code for a lot of the detail. And then the code says the basis upon which you should be providing your regulated financial advice is determined as a minimum by the New Zealand Certificate in Financial Services Level 5 version 2. So that's the academic qualification, but it's not just purely a theoretical qualification. It's really around the practical implementation of regulated financial advice. So although it is an academic qualification, it's special in that it sets the standard of the practical implementation around what does a good client file look like? What would a suitable advice document look like? And then within that level 5 qualification, there is some very well-defined assessment criteria that our assessors at Strategi Institute have to use in order to work out whether someone has passed that particular assignment or not. And it's that assessment criteria which is the expectation that advisors and FAPs need to be meeting on a day-to-day basis, because the code says that's the minimum standard at which we need to operate at. So Nick, a couple of questions for you around this suitability and client understanding. So often clients will say to me, well, sure, I see that section 431 that talks about I've got to ensure that advice is suitable. But what is suitability? How do I determine it? If something went wrong and I had the front up in court, what's my defence around whether it's suitable? Any thoughts around that?
Yeah, I mean, look, it's a tricky one because it's going to depend on the context. In fact, that's recognised in the code standard. So, talking about advice that's suitable for client, I mean, having regard to the nature and scope of the advice and thinking about the client. So, look, it's a tricky one for a lawyer to answer because the answer is really it depends. I mean, I would always say come back to the commentary and the code standard, and this is probably a question to both giving advice that's suitable and then ensuring client understands. It's going to depend on the circumstances. If you're dealing with a reasonably astute, sort of person who's got a bit of experience in investing and the like, then the threshold in practice is going to be much easier to satisfy than it is if you're dealing with someone who's vulnerable. So, I mean, look, I will always direct people back to the commentary. I think they provide some quite good guidance as to the type of factors that you have to think about. And I certainly agree with the comment you made before, David. It's around providing a total picture, good and bad, as part of your advice process, and particularly if you're dealing with something like replacement business. That's really where you see problems arising, is if there's been a failure to, provide balanced advice and look at both sides of the picture.
Cool. And so often the other one there is around you've got to take reasonable steps to ensure the client understands financial advice. So often advisors are saying, well, how is reasonable steps determined? And like in the past, what a lot of advisors used to do, a lot of AFAs, they used to take all of the information they've got from the client, regurgitate it in the form of a whopping big statement of advice, which in some cases is 30 to 60 pages long. And then they give it to the client and the client signs off. And they're going, well, I've fulfilled my obligation because I've given them everything. So to me, that's reasonable steps is the way that they thought in the past. How do you reckon it should be interpreted in the new regime?
Yeah, well, look, that's certainly not the answer, is it? I mean, it's regurgitating is great from a file management perspective and being clear around factors you've taken into account. But, is the client really going to understand that? Less really is going to be more for something like that. And again, I know it's a non-answer, but it depends a lot on who the client is and whether you're giving a simple piece of advice or it's a full financial plan. And I mean, well, I suppose I would say again, the commentary to the code standards recognise that it's fact specific. Unfortunately, you won't convince me or any other lawyer to say in any particular case you must do A and you're fine. And that comes through clearly in the few decisions that we've got out in the past as well.
Right. And so how would an advisor get comfort around their client having understood something? Do they have to ask them questions, simply getting the client to sign something saying that they've read and understood it?
Look, I would probably do both. I mean, talking to your client, having an engaged discussion with them about the advice and do they understand it and do they have their questions and testing their understanding is clearly the best way to test understanding. The tick box, if I've understood it, is serves a purpose as well, but that's largely more of a record keeping and backstop thing. There's no point in getting a client to tick they've understood something if they haven't. That won't offer you any real protection at all.
Cool. No, thanks for that. So one of the things we always talking to our clients about in the new regime is to ask your clients as part of the fact-finding process, how do you want us to communicate with you? How would you like us to provide the advice through to you? In other words, do you want it in paper or do you want it electronically? And then do you want everything in one big document or do you want a simple, easy to understand summary? And then we'll give you the links to where you can read all of the detail if you want to. So to us, it's key around helping build around this understanding and suitability, the methodology and how they learn and understand and want to be communicated. So you need to be building those sorts of questions into your fact find as you go. So if we look at the next slide, which is
David,
around
just before we progress, we've got a question from the floor here. Someone asking an example of what isn't good about a policy. So do you mean the general exclusions, or is there something else that we need to refer to? So the original question was, can you give an example of what isn't good about, say, an income protection policy? And then followed up with, do you mean the general exclusions, or is there something else we need to refer to?
Yeah, so it's a good question there. So you don't want to get into all of the nitty-gritty detail, because the real small detail, fine print, you can have a link through to the relevant policy document and things like that. It's talking around the high-level stuff around, if you're moving from one product to the next, is there going to be stand-down periods? What's the wait periods? Are you giving up some other benefit by moving across to the new product? Does this new product exclude something along the way, or only pay a certain amount? Or in many cases, it may not pay out at all, depending on the employment circumstances of the individual. So it's putting those things at the high level. So in other words, Mark, it's the key risks and disadvantages as opposed to down at the micro level. Anything you want to say around that, Nick?
No, look, I agree with that. I suppose the question again is whether you're talking about particular products or, if you're doing replacement business, for example, or advising on, income protection from a particular provider as compared to helping someone decide, do they need income protection? Do they need TPD? Do they need, a different type of cover? And in that case, I wouldn't have thought you could answer that sensibly without providing information about good and bad.
And increasingly, we're seeing people using links. Whereas we go back sort of 5-10 years ago when the internet wasn't as stable, people had to put everything into appendices or PDFs or whatever, but now links are pretty standard. But links, this is where you've got to be a bit careful though in your advice process, because if you're doing paper-based delivery of advice documents, then a link is useless, because you can't click on a link, a hyperlink on a piece of paper, and so therefore you have to sort of have another mechanism that people can go to, whereas when it's electronic, it's just fabulous around how all that can work. Okay, anything else there, Mark, before we move on? Cool. Okay, Hayley, if we just move to that next slide. Okay, so what we're talking about here is the 6-step advice process. So let's put this in context for a sec, because a lot of people go, well, geez, why is New Zealand sort of dreamt up this 6-step advice process? But the reality is this is a global standard. It's the ISO 22222 Financial Planning Advice Process International Standard that is used globally. Now, when it originally came out, donkey's years ago, it was before technology was used in the advice process. So it was a very linear process where 2 followed 1 and 3 followed 2 and so on and so forth. And so it was quite static, whereas today people think quite differently. So we've devised this wheel now, so it's a process that goes around. And so you're constantly using that process as you go. Different people will use different terminology, but when you look at it in the level 5, that diagram uses the actual wording that we're sort of talking about. So when we start looking through at all of this, the first thing to keep in the back of the mind is that the new regime enables advice to be delivered digitally or by us as humans. So when you look at digital advice, like some of these new robo-advice platforms, it's really friendly, it's interactive. You don't see standalone disclosure statements or documents. What you see is the disclosure is embedded into the screens. And as you're doing something or entering things, up will pop a box and go, oh, by the way, we get paid $200 for that. Or by the way, we have a conflict here in yada, yada, yada. And it's really clear around what's actually happening. So when you look at the digital advice type of platforms, right at the beginning, it's helping establish the scope by saying, welcome to our site. This tool or this site is ideal for people who want, and then it lists the sorts of things. But we're no good for people who need this, this, and this. If you're one of these who need these things, click here to get a financial advisor. So it's clearly in clear, concise, and effective terms telling people, and it's acting as a draft gate for people and saying, we're suitable for this, but not suitable for that. So this is starting to work through the scope. And then as it gets through screens, it's doing further drafting of that. So that the scope of advice is an iterative process as opposed to being a really formulaic type of form that you have at the beginning. But having said that, when you're a paper-based operation, then often having some form of scope of advice document is a good idea. The problem is, clients come into you at the very beginning of the interaction, and they may have a fixed view of what they want from you today. However, once you start engaging with them, you're expanding their thought processes out, and before you know it, they need some additional services. So you don't want to be too rigid in your scope of service. By all means, tick the box or have the form there around what they want, but perhaps just don't get the client to sign it until the end of the fact find discussion, because you may need to go back and expand in on that scope. Also, what we're finding is having fewer documents is often easier because you've got the ability to take aspects of the process and embed them into a smaller number of documents. So increasingly, when we're doing fact find documents, we will embed into those the scope of advice, and we'll put that at the beginning as we go through. Now, as we say in the slide here, under the law, you don't have to have your advice in writing. There's nothing that says it has to be. It could be a video. It could be a series of pictures. It could be a PowerPoint slide, which obviously is in writing. It could be an audio, or it could just be straight verbal. But you've still got your record keeping obligations under the FAP license. So if you haven't got some form of documented evidence, then you could be falling foul of your record keeping obligations from that sort of perspective. So most people end up having some form of written advice as they go along. Now, the more you become innovative and the more you move away from purely having everything documented and sent to the client, then the more important it becomes to have a documented advice process. By being able to show the regulator if something goes wrong, here's my process, and this is what I do in every single step, and this is how I train my advisors to follow those steps, and this is how I check that my advisors are following that process. That becomes quite a defendable methodology. So if down the track a client sort of challenges you and may want to take you to court or through the dispute resolution service, if they're saying, the advisor never told me that, the advisor never showed me that, well, it becomes he said, she said type of thing. But if the advisor can then go back and then show the organisations, here's our process, and I can trot out 50 people who can all testify that we did do this, then suddenly it weakens the client's arguments around some of that. So, Nick, is there anything you want to say around that sort of concept?
Yeah, I just jotted down 2 points probably to reiterate. The first one is a bit of a lawyer's point on record keeping. And I mean, failing to keep records is makes you non-compliant in of itself, but it's also monumentally stupid because you've got no way to defend yourself if someone complains, and you know that's the point you've just mentioned, David. And as a result, yeah, there's flexibility about not providing advice in writing, but you still fundamentally have to have something in writing for your protection and also I think for clients' benefit. Second comment probably to add is that less is more. You mentioned at the start of the slide around clients, advisors commonly having less documents, and that certainly, I agree with that comment. That's what I'm seeing as well. And that's fundamentally a good idea, because it makes it simpler. The less documents you have to manage, the less templates you've got to keep updated, the less things you can forget. And the easiest example, I think, of where I'm typically seeing that is disclosures that were previously standalone being incorporated into scope of engagement and statement of advice and so on. Easier for you all to manage, and a better outcome for clients as well, I think.
Yeah, like we're firm proponents of integrating the advice documents into the process, so it's as seamless as it can be. Whereas, unfortunately, at the moment, because people are nervous about the regime, they're actually having standalone stage 2 documents, stage 3 documents, and we're going, well, if you've got a statement of advice or whatever, you can put your stage 3 around the specific remuneration into your SOA, or if you're a product provider, you can put it into the policy contract statement or whatever, So they're the sorts of things to do. I was with an advisor firm the other day with about 20 advisors, and they were bitching and moaning around how much longer it's taking them to do their statements of advice. And I said, so what's the problem? They said, oh, we've got to calculate all this remuneration, and then we've got to put it in. And I said, but guys, that's not a regulatory issue. That's a software issue. You need to go back to your software providers and get them to improve the solution, so that when you recommend a particular product and you enter it into your system, it automatically spits out the remuneration levels for you. So you can speed these things up through technology. Anything you want to say around any of that, Nick?
No, look, I agree. I've seen some great template statements of advice that really do a good job of drawing that stuff in. I've seen some probably at the other end of the spectrum. You're right. Technology is an enabler for preparing these types of things. There's always a balance, I suppose, between investing the time and money, because it is money, and getting systems to do it for you, as compared to, having a template that gets you, 90% of the way there and doing the rest with a calculator or whatever. But I agree with those comments.
Great. So I'll get into advice documents shortly, but just some of the high level things around these processes. You even with a small business, you want to look at 3 lines of compliance defense. So your first line of compliance defense is around having good templates, having a checklist for what goes in your client file, having some peer review between one advisor and the next. In a bigger business, you'll have a second line of defense, which may be your quality assurance process, and a compliance officer who will then periodically sample the files to make sure that everything is okay. Because what you're trying to do through peer review and quality assurance is avoid the fundamental issues of advice being issued that is incorrect at the beginning. Like, it is common for us to see at Strategi files of client statements of advice where the name of the client changes from the beginning of the document through to the end. The amount that they're investing changes. The products that they're buying insurance on changes. And what's happened there is the advisor, instead of going back to the base template, has overwritten a similar client template along the way. And then the phone might have gone, or he's done whatever, and before he knows it, out goes the statement of advice. No one has peer reviewed it, and there's these errors throughout it. Now, this is a common issue, and so it's not a legal problem that our legal structure hasn't created this issue. It's a fundamental business issue around quality control for that. Now, so as an industry, we have been really, really good at steps 1 to 5. And that's all around onboarding a new client and advising them and selling them products and things like that. But the reality is, in the life cycle of a client, an advisor and a client will spend the majority of their time in step 6, which is the ongoing monitoring and review of clients. And this is, as an industry, this is a very generalized comment. As an industry, we are poor on ongoing servicing of clients. So in my case, I value advisor businesses. So at the moment, I'll be doing at least one advisor business valuation every single week. And it's common to see an advisor that will have several thousand clients, but no client files. All they've got is a series of names, a commission schedule, and in some instances, they'll have an email address. So step 6 is not occurring at all in most instances, or if it is, it's very rudimentary. And what we've got to be mindful of is that this suitability, we've got to be able to ensure that the product is suitable for the client. That's not just at the beginning when we sell them the product, it's throughout the lifetime of our relationship and contract with the client. So we need to be focusing and developing methodologies, training, documentation around how on a regular basis we can put our hand on our heart and prove to the regulator that client the product is suitable for their needs. So Nick, anything from a legal perspective you want to talk around long-term suitability?
Not really. I mean, I suppose sorry, I've been distracted by looking at some of the questions that have come in. But no, I mean, it's got to be part of an ongoing relationship, doesn't it, more than anything else?
It does. Yeah. So some of the trends we're seeing in the advice process is an increasing use of secure client portals. So in the past, advisors and clients would email backwards and forwards. So both parties may have their actual data secure, but the weakest link is the email link. Whereas now what we're seeing is a lot of product providers and larger advice firms are having secure portals, which are really nice and user-friendly. You load all of the documentation the client needs before the meeting into that portal. It triggers a notification out to the client. The client goes online. They complete the documentation. That sends a trigger back to the advisor, and then they can work electronically on that, or the advisor can have his or her laptop with them in the meeting, and they can work through and do all of those things. And that way, then it's a seamless process, and we're not sort of exposing sensitive client data to potentially being lost and hacked. The other thing that's happening in the advice process is, and I'm really pleased about this because it's been a personal sort of crusade of mine, is we're moving from consultative advice through to collaborative advice. So consultative advice is the old-fashioned way where the advisor was the font of all knowledge, and a client went and saw the advisor. They filled out some form of form. The advisor went away into the back office, and days or weeks later, they produced a statement of advice. The clients never read it because they didn't understand it. They just trusted the advisor, and things happened. Whereas in the new collaborative advice process, the advisor becomes, instead of the font of all knowledge, they become the trusted librarian. So they have access to more information than perhaps the client has through Googling. And so the advisor works collaboratively and interactively with the client in the meetings to build up scenario-based solutions. And they're testing these solutions with the client as they're going. So that way, then, when the advice documents come out, they're not a whopping big surprise from that sort of perspective. But the key trends we're seeing is clients are unanimously saying we want advice that is faster, simpler, cheaper, easier to understand. So they want more for less, and they want it quicker, and they want it looking nicer from that sort of perspective.
We've got a couple of questions at this stage.
Yeah.
One question is around the disclosure. Please provide tips as to how you give required disclosure prominence when incorporating disclosure within advice documentation. So if the advisor chooses to put their stage 2 and stage 3 disclosure in, for example, their engagement letter or their statement of advice, how do they ensure that that disclosure meets the prominence requirement in the disclosure regulations?
So I'll start on that, and Nick can sort of add to it. So the prominence thing is really primarily around stage one on your website. The other part of it around prominence, well, it will be there in some shape or form, but it needs, whatever you do around the disclosure in stage 2 and 3, it can't be in the fine print. It can't be in a smaller font or less visible font than the main sort of part of what you're talking about. You can't hide it away somewhere. And so the way you make things prominent is through a heading. Say, hey, some important information you need to know about. So you can use whatever terminology you want, as opposed to saying disclosure or something like that. You can then, if you want to, you may want to bold something, or you may want to put it into a box from that sort of perspective, so that it's there. Increasingly, we're getting advisors to use what we call thumbnails, where things pop up. So it's got a little picture, and the client clicks it on the electronic documentation, and it expands out to have all of that sort of stuff. So anything you want to say, Nick?
Yeah, look, there's any number of ways to do it. I think it is more than not putting it in the fine print. Clearly that's a starting point. It's not in the fine print. It's not in the appendix. It's not in 2-point Arial. I think it's a higher standard than that. Giving it prominence means drawing clients' attention specifically to the disclosures. And I mean, I agree with you, David. I've seen it done in many different ways. This is actually something that's easier in an electronic advice process, because you can make people, read through it and move forward. In a, more traditional paper-based advice process, up front in the document, headings, as you say, wording in perhaps your introductory, comments or cover letter, or however you do it, that draws people's attention to it. That type of thing. I mean, it's not a case of having to be the only thing on the front page, for example, but it's more than just standard text or bearing it, and it's got to be clear for clients to find and understand.
Cool. Was there any others there, Mark, you wanted to address?
One other comment actually that's really worth bringing up, and this is around the use of research. So for example, in the insurance space, where advisors will have research providers, they'll pump out a research report, and it's just a note that the research report itself isn't specific to the client. So having the research document slapped onto the back of a statement of advice that says the research says this, therefore this is what I'm offering you, probably isn't enough. You need to go into a little bit of depth as to which product is right for the client and why it's right for the client. And the research is just to support that, not to take its place.
Yep, fully agree with that. And that's why in many cases, if we're building some of these advice docs, rather than embedding the research document actually into the main document, we'll give the recommendation and go, for further information, read the additional research on this product, click here, or whatever it happens to be, or go to appendix yada yada to see that document. If you're embedding it into the main document, it sort of distracts the flow. So you're going through, talking through things with the client, and suddenly there's this whopping in-depth research report that's in the middle of the document, and that's where clients go, they glaze over and they lose interest. So you want to keep those things out to one side. Okay, so moving on then, if we just sort of move to the next slide. So we've got some common advice documents. Now, the important thing to keep in the back of our mind is there is no prescriptive set of documents, because a call center that's going to do the advice verbally and is going to give the advice in less than half an hour isn't going to have all of the documents that we're listing there on the screen, because they're going to collect a lot of that information verbally and they're tapping it straight into their system. And then the real advice output is the documents that come out the other end. But if you're doing more complex advice or more traditional advice, then you will tend to end up with those sorts of advice documents. Now, people commonly think that the advice document is only the statement of advice, but it's not. It's all of the documentation around the whole process, because you could be giving advice in the first meeting in many instances. And so you want to be iteratively building that up so that it's the entire client file. we're a firm view, our view is quite firm that if you do something with the client and you record something with the client, you should send it to the client. So what I do in an advice meeting with clients is I'm a scribbler. And I write on a piece of blank paper and key words that I'm discussing with clients. And I have the clients sitting there and I draw them pictures and everything else. And so what I then do immediately at the end of it, I get my cell phone out because I'm a firm believer in using my cell phone. And I take a picture with my cell phone of all of the scribbles I've done for the client. And then I give those scribbles to the client and I put their name on it and the date of our meeting. So they've got that copy, but I've also now got the record sitting in my phone. And so that becomes part of my fact find, and it also becomes part of my file notes along the way. I find that with some clients, they don't like going through big, long fact finds because it's just too hard. So in many cases, when I've established that they don't like that sort of process, I'm sufficiently experienced to know the key questions I need to ask. So I go, hey, rather than using the form, would you mind if I recorded this on the phone? And then I can send you a copy of that recording if you like at the end. And they go, yeah, that's much easier, Dave. And so we just chat away and I'm just noting stuff down in my scribbles and things like that. So what I'm trying to say here is there are some key sort of document stages we need to fulfill, but it doesn't have to be hard-coded into specifically named documents. However, as you build out a process and as your businesses become bigger, then you do need to become a lot more formalized in what you're doing. So, because you need to be able to get consistency in the business. So I'm certainly not advocating you throw everything away, but I'm just saying that different clients interact in different ways. But some of the trends and some of the things that we're definitely doing in advice documents is we're putting in more pictures. So if clients talk about goals, we go, well, have you got a picture of what it is you're trying to do or whatever? They have those on their phone, so they just share those with us. And then we embed those pictures into the statements of advice. We're using a heck of a lot more color now because clients expect that. They're used to seeing colored documents, and color doesn't cost you any more than black and white when you're doing digital type documentation. We use lots and lots of drawings and diagrams to explain things. It's that old adage of a picture's worth 1,000 words. And so what we're doing is if we can get a concept across in a picture, then that's what we'll do. We also use a lot of links. So the advice documents now is like just a key summary of what we talked about and the recommendations and why. It's not all of the in-depth information. That in-depth information, we either have a link that will go through to the client portal or a link that will go through to, say, an appendix in the document. So what we've started to, or we've been doing it for a long time, we've been taking advisor businesses and product provider businesses, which used to perhaps do 30 to 60 page statements of advice, and we're trying to get those statements of advice down to 7 to 10 pages. Now, it's harder work to condense something down than it is to put more stuff into a document. So as we condense it down, the compliance around trying to make things shorter becomes more intense. But it's all around client understanding. And so what we've worked out through lots and lots of testing, if you give the client a 7-page document and talk them through that, they've got A, more chance of reading it, and B, more chance of understanding it than you sending them a 30 to 60 page statement of advice. So links are important, and also thumbnails. So that's what I've talked about before, where if you've used a document, like let's say we're talking about life insurance, and we talk about a particular provider, in the interview, you will have the advisor, the product provider's summary sheet that talks around this is the product, this is what it is, here's the key features, benefits, blah, 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 and what it does and exclusions. We're a firm believer that if you've shown something to the client in the interview, then regurgitate that in the advice doc. But you don't have to have it sitting there taking up the whole advice doc. All it is a tiny little thumbnail, and you've got some wording that says, hey, if you want to sort of find out more, click here. And then the thumbnail opens up. And then once you've read it, if they want to read it, then they just click it and it collapses. So it enables people to decide when they want to read the detail, as opposed to the detail being in their face all of the time. Some of the things we've done is we've gone to try and reduce client sign-offs, and I'll get Nick to talk about this, because what unfortunately we're seeing is people are putting more client sign-offs into the advice process, whereas technology enables us to be a lot more innovative and to get client consent in other ways than getting someone either electronically or on a piece of paper to scribble down their signature. So any thoughts around any of that, Nick, from a legal perspective?
Look, I mean, you're right. So I'm a bit conscious of time, but you are right. I mean, consent does not need to be a signed piece of paper. And in fact, in a lot of ways, that's kind of an unnecessary burden for everyone. So many different ways of doing that: email, consent, tick boxes, and the like. It's largely around evidentiary, the benefit of it, in the sense that you want to have confidence that it's actually your client. But yeah, very many different ways to achieve that these days that don't require a signed piece of paper.
Great, thanks. And then the other thing we're doing is we're heavily into information sheets. So we work with firms, and we go, what are the sort of common questions that clients ask? And then we help them build out these information sheets, which are then factual documents, which means they can be attached to the advice process, or they could be sent out separately from the statement of advice. But the statement of advice can reference information sheet 1 or information sheet 2 or whatever it happens to be. And that has additional supporting information to help clients make their mind up, but it doesn't have to be regurgitated into the main document. The other big change in the new regime is that the advice doesn't have to be in English. It can be in whatever language the client is most able to understand. But under our record-keeping obligations, we need to be able to easily and quickly retrieve that and translate into English for the regulator. And so the areas that we're spending a lot of time building out at the moment is around operating with WeChat, because if you've got Chinese clients, WeChat is what they use. And it's not necessarily the easiest system to build up an audit trail on. So from a compliance perspective, you've got to address WeChat and how you're going to handle that, and also how you're going to handle any form of translation. Because simply taking a Chinese a character sort of document and then putting Google Translate across it could end up giving you a whole lot of gibberish. So you need to make sure you've got someone who's pretty skilled in translating it in a more sensible way. Right, if we just move on to the assessment around compliant documents or compliant advice. So what we're talking about here is there's no hard-coded right or wrong. But when we're looking at it from a level 5 version 2 perspective, the way we assess things, and we do the same when we're doing compliance assurance reviews, we look at whatever it is and go, has the client and the advisor set the scope? And is that scope pretty clear and understandable? Is somewhere in here in the whole process, are the client's goals clearly articulated? And we've heard about the SMART way of doing it, the SMART way of articulating it. And that's a good way of going. But the important thing is there's no point having advice and saying it's suitable if we don't know what it's suitable for. So being able to clearly identify what the client's goals are in a language that the client is likely to understand is quite important. The simple way we do it, like the 3-minute check, if I'm looking at an advice document, I will look at it and go, what's the scope? What's the client's goals? And then I go straight through to the recommendations and go, are these recommendations A, within the scope of what they agreed upon, and B, do they have a decent chance of achieving the goals? And sadly, often it doesn't meet either of those two things. But if it does meet those things, well, then it's probably 80% of the way there. Whereas, sure, ticking the boxes and getting all the other things, they're also very important. But if the advice actually achieves the client's goals and the client actually understands it all, well, then we're achieving a lot of the principles within this new regime. The other thing is then around sufficiency of information, and that's what I've been sort of talking about. We need to ensure we've given the client sufficient information to be able to make an informed decision. So having that in those links or as appendices is a really good way of going, or having supplied them with a lot of the information in the initial meeting and then simply referencing in the meeting that this is based on this document that we gave to you in our meeting dated whatever. And then the clear, concise, and effective, which is the mantra that the FMA sort of espouses all the time. This is fundamental to client understanding. It means we've got to strip out jargon. We've got to use simple, easy to understand language that clients can grasp the meaning of. Remove any form of ambiguity, take away the formality. Less is more, so to speak, because if it's concise and we can say it in a bullet point versus a paragraph, clients are more likely to A, read it, and B, understand it. And then the effectiveness is the thing around, has the client actually grasped what we're talking about and is actually going to take action? The thing that sort of concerns us the most is, from a compliance perspective, you'll see client sign-offs or acknowledgements at the end of advice documents. One of the first acknowledgements is typically something along the lines of, we hereby declare we have read and understood the statement of advice and all supporting documents. And when I talk to advisors, I go, do your clients honestly read this stuff, and have they read all those product disclosures? And almost every advisor, without exception, says, no, Dave, none of them read it. They just go ahead because they trust us. So the point I'm trying to make here is simply adding in words to try and get the client to say that they've read and understood it. That's probably not sort of fulfilling good conduct and the spirit behind what we're trying to do. Anything, Nick, you want to say around that?
No, I mean, look, I agree that there's a real challenge around simplicity, but the reality is that's what that's what clients have said and they need. And I totally agree, and I'm a lawyer, so I will always put that tick box in a document. But it's a backstop, and if your client hasn't read it and hasn't understood it, then there's absolutely no point in getting to tick that box.
Yeah, I agree. And then the last one on this slide is just be careful with family trusts. So a family trust is not ma and pa sitting in front of you. It's a separate entity. And you've now got the new Trust Act of 2019. And so there has been some changes, and a lot of the duties of trustees are now more hard-coded and defined in the Trust Act. So when you're talking about family trust, clearly identify, is the client the family trust, or is it mum and dad that are in front of me? And am I talking about the trust's assets or about mum and dad's individual assets? So just summing up and moving sort of through so we can hand back to Mark. So if you just sort of move to that next slide there, Hayley, please. So in summary, we're saying there is no one standard methodology. Advice needs to be tailored to the type of product, the methodology of delivery, and to the type of client we're dealing with. Keeping in the back of our mind this whole concept around vulnerable persons or vulnerable clients, because your advice does need to change, because some of your clients will be deemed vulnerable persons, and you need to take greater care around that. So you need a vulnerable persons policy in some shape or form. We've obviously got to meet our legal duties under FMCA and the code, and that also means that the minimum standard that we need to be working at is the equivalent of the level 5 version 2. Hard to know if you're meeting that standard if you haven't actually gone and seen what that standard happens to be. So this is where competence, knowledge, and skill comes into it. keep in the back of our mind all the time that this is not a prescriptive regime. It's principles-based. And provided we can clearly demonstrate to the FMA that we have abided by the principles, then we've got a fair amount of wriggle room in which to operate. And that wriggle room will help foster innovation in the way we deliver advice, because consumer expectations are moving, technology is improving, and so we've got the ability as advisors and as product providers to be really creative and innovative in the way we do things. If you're building templates, and particularly as you're making your templates shorter and more condensed, make sure you get them signed off by a professional, because if your fundamental templates are incorrect, then it's going to cascade through and create all sorts of compliance issues further down the track. And all the things we've been talking about is sort of more of the hard-coded stuff, but you've got to overlay over the top of that the inherent competence, knowledge, and skill we need to have as financial advisors. The more we understand the regime, the more we understand the products, the more we understand the clients and the way they make their decisions and their issues and concerns and vulnerabilities, then the better the advice we can provide. So we can have all of the systems and processes in the world, but it doesn't work as efficiently if we don't have trained people to be able to do it. And above all else, we've got to be working in clients' interest. Think about our clients all the time in every single interaction we have. So just the next slide there, Hayley. So anything, just sort of final summing up and next steps, anything from you then, Nick, around anything we have or haven't covered?
Oh, look, we haven't covered lots of stuff, but we could spend all day talking about advice processes and the regime. But no, look, I mean, I just endorse all your comments, really. I mean, the regime is flexible, but that's scary. And, you know, I think we all understand that.
Awesome. So thanks for that. And thanks, everyone. And I hand back to Mark to wrap it all up.
Thank you very much, David. So the last slide here around, as you can see, was around reviewing your advice process, seeking some professional advice, and get feedback from your clients. The last thing for me to do here, as well as thanking David Greenslade and Nick Summerfield for their help, is just to talk about the next webinar, which is on navigating the education obligations. So a little bit more about the ticket to the game, the requirement for a level 5 or equivalent, and then also about the ongoing CPD requirements and how you can meet those. That webinar is on Friday, the 25th of June at the same time, and you can find the registration details at this link. You can always go to advice.fsc.org.nz to find information about these webinars, where you'll also find a recording of this and earlier webinars. And you can contact that email address, fsc@fsc.org.nz, to subscribe to the mailing list and get all of the information as it comes. So final word here again, thank you very much to David and to Nick. I hope you've all found something useful out of this webinar and continue to do so out of the series. Please email through your feedback so we continue to make sure we meet your needs. Thank you very much, everybody. Have a great day.
Bye.
Thanks, everyone.